Good afternoon, welcome. Happy International Underground Railroad Month. Thank you for joining us today. I hope everyone is doing well. Closed captioning is available for those who need it, this capability. The link is in the chat. The chat for this event has been disabled for participant discussion, but you can enter in your questions at any time in the Q&A and they will be answered. This session is being recorded. Information regarding the availability of the recording will be sent to the email you registered with. My name is Deonda Johnson, or Day as most of you know me, and I am the Midwest DOI Regions 3, 4, and 5 Regional Manager of the National Park Service National Underground Railroad Network to Freedom Program. Legislated in 1998, the network sets and promotes quality standards in its coordination of education, preservation, and commemoration efforts related to the history of the Underground Railroad, which it defines as resistance to enslavement through escape and flight. We consider it the nation's first civil rights movement. The network is pleased to partner with Gratz College, located in the greater Philadelphia area, in bringing you today's virtual discussion on the Underground Railroad and the Constitution with Dr. Paul Finkelman. This event is being held in honor of Constitution Day. I know we are a day late, but not a dollar short, as we delayed the event to avoid a conflict with the anniversary of Harriet Tubman's 1849 escape on the Underground Railroad from Maryland, which occurred on September 17th, and is in part the reason why International Underground Railroad Month is September. But any day should be appropriate for looking at one of the foundational documents of our democracy. There has been lots of discussion recently on whether or not the Constitution is a pro-slavery document. I thought another way to explore this issue was to look at its relationship to the Underground Railroad. The Underground Railroad is relevant to so much, including things that are going on in our nation right now, but that is a discussion for another time. Now to introduce our distinguished speaker, Paul Finkelman. Paul Finkelman became the president of Gratz College in 2017. He received his BA in American Studies from Syracuse University and his MA and PhD in History from the University of Chicago. He was later a fellow in Law and Humanities at Harvard Law School, where he also taught one course. Before coming to Gratz, he taught in the History Department and law schools at a number of universities, including Duke Law School, Washington University in St. Louis, and the University of Texas. He held the Fulbright Chair in Human Rights and Social Justice at the University of Ottawa College of Law and held the Ariel F. Sallows Chair in Human Rights Law at the University of Saskatchewan. He was a scholar in residence at the National Constitution Center in Philadelphia and a fellow in the Democracy, Citizenship, and Constitutionalism program at the University of Pennsylvania. He has published a wide variety of subjects, including human rights, slavery and human trafficking, both historical and modern, American Jewish history, American legal history, constitutional law, and legal issues surrounding baseball. His most recent book, a new edition of Defending Slavery, Pro-Slavery Thought in the Old South, came out in 2019. The US Supreme Court has cited him in 5 decisions involving civil rights, affirmative action, and the Bill of Rights. Most recently, Justice Ginsburg quoted him in her opinion for a unanimous court in Timms v. Indiana in 2019. He is also the leading President Millard Fillmore Scholar, which he neglected to include in the bio he sent me, but thought it was appropriate to mention because he signed the 1850 Fugitive Slave Act into law. Without further ado, ladies and gentlemen, Dr. Paul Finkelman.
Day, thank you very much. It is a delight to be here. It's an honor to be here, and it's actually an honor to work with the Freedom Trails program, because I think this is a central piece of understanding America, remembering our history, honoring people who took great risks to help people who are free, who were not free to become free, and to understand the world we live in today. Just one word about Gratz College. We're a small college. We have been online for almost a decade, and so we are running at full speed. We have many programs in education, masters and doctorates in education. We also do a PhD in Holocaust and genocide studies and a master's in that field. And that relates to what I'm talking about today, because of course the Underground Railroad was a fight against a kind of genocide, and it was a fight against discrimination and repression of people. And so in honoring the Underground Railroad, we also tie ourselves to other aspects of history, world history, and modern events today. So let me start with the question that Day just raised. Was the Constitution pro-slavery? And the answer is yes. And this is hard for some Americans to come to terms with. Americans don't like to think about the Constitution as being a document which protected and preserved slavery in a lot of ways. On the very first day of debate in the convention, the issue of slavery was raised. On the very last day of debate, when two delegates refused to sign, they said that one of the reasons why they were not signing the Constitution was because it protected the African slave trade. This example, the bookends, if you will, of the debate over the Constitution, illustrate that slavery was there on the first day, it's there on the last day, and it's there all the time during the convention. The Constitution provided a number of very specific provisions designed to protect slavery. We all remember the 3/5 clause. The 3/5 clause does not say that African Americans are 3/5 of a person, although sometimes people think that. What it says is that when you count people for representation in Congress, you'll not only count all of the free people of the South, but you'll count all the slaves at a 60% ratio. Southerners, by the way, wanted to count slaves at 100% ratio because that would have given them more representation in Congress. Northerners didn't want to count slaves at all for purposes of representation because, as a number of delegates said, if you think slaves are property, how can they then be counted for representation? And one delegate, angrily said, does a master get as many votes as the master owns slaves? Nevertheless, the 3/5 compromise was in there. It gave the South extra representatives in the House of Representatives. And one of the laws we'll be talking about today, the Fugitive Slave Law of 1850, could never have been passed if it were not for those representatives that were created by counting slaves in the South. In addition, something people often forget, the Electoral College allocates presidential electors to each state based on the number of representatives they have in Congress. So the South got extra presidential electors because of counting slaves for purposes of representation. The Electoral College, in some ways, is the last vestige of slavery that affects modern American life today. Thomas Jefferson would not have been elected president in 1800 if slaves had not been counted for representation and slaves had not been counted then to increase the electoral votes of the Deep South. The Constitution gave Congress the power to regulate all international commerce. Article 1, Section 8 gives Congress this enormous power to regulate all international commerce. And then in Article 1, Section 9 says, however, Congress can't pass any law prohibiting the African slave trade before the year 1808. Now, the framers didn't use the word slave, not because they were afraid of it. All of the debates talk about slavery. They use the word over and over again. But they don't use it in the Constitution because they are afraid that some Northerners may not want to ratify the Constitution if they see that slavery is embedded in it in so many ways. So the 3/5 clause talks about 3/5 of all other persons. The slave trade provision talks about such persons as the states might want to import, without mentioning that we're talking about slaves. The African slave trade clause led to the importation of about 50 to 60,000 African slaves in the 5-year period from 1803 to 1808. It was the largest number of African slaves brought in to either the American colonies or the American states at any time in such a short period of time. Then there's the Fugitive Slave Clause, which is why we're here today. Fugitive Slave Clause simply says that persons who owe service or labor, again, not using the word slave, persons owing service or labor who run into one state cannot be freed by the laws of that state, but instead must be returned on demand of the person who claims their service or labor. At the Constitutional Convention, there's very little debate over the Fugitive Slave Clause. It's introduced one day, a few Northerners mock it. One Northerner says, you want us to keep track of your property, as you call these people? Are you going to run after our runaway horses? They're not comparing slaves to horses. They're making fun of the Southerners who suddenly say, oh, we need the Northerners to help us capture our property because we can't take care of it ourselves. Nevertheless, it passes. It's added to the Constitution. And there's not much discussion about how it will work. Furthermore, excuse me. Furthermore, during the debates over ratification, no Northerners seem to have noticed this clause. It's at the back of the Constitution in Article 4. It's buried. Nobody talks about it. Many of you read the Federalist Papers in college or even in high school. And the Federalist Papers are seen as a way of understanding what the American Constitution is all about. But the authors of the Federalist Papers don't say a single word about the Fugitive Slave Clause because the Federalist Papers were designed to get New Yorkers to vote in favor of the Constitution. Obviously, talking about fugitive slaves would not have helped to get the Constitution ratified. If you read the text of the Fugitive Slave Clause, Article 4, Section 2, Paragraph 3, for any of you who want to find it, it seems to be saying that the return of fugitive slaves is an entirely a state-to-state matter, that it's not an issue for the federal government. And it's in a section of the Constitution which deals with interstate relations, not federal relations, not federal powers. Nevertheless, in 1793, Congress passes what's called the first Fugitive Slave Law. Under this law, people who claim a runaway slave can bring that person before any state or federal judge upon proof that this is indeed their runaway slave. The judge will give a certificate of removal to the claimant, and the claimant can then take that fugitive slave back to the state where she or he ran away from. There is a provision for a $500 penalty for anyone who interferes with the return of fugitive slaves, and there's a provision of a lawsuit for the value of a fugitive slave if someone helps the slave escape and the slave is not recovered. The law is not enforced particularly well for its first 20 or 30 years, in part because transportation is slow and difficult. It's hard for a Southerner to figure out where a slave might have run away to. And those slaves who are fortunate enough and lucky enough and brave enough and skilled enough, because it takes all of these things, to escape to the North, often simply melted into Northern society. But by the 1820s, transportation networks are better, especially with steamboats, and then in the 1830s you have railroads. And Southerners become more aggressive about going after their fugitive slaves. This leads Northern states to pass what are called personal liberty laws. Personal liberty laws simply say, if a state judge, here's a fugitive slave case, the state judge can issue a certificate of removal, but only if the state judge is actually convinced that the person before the judge is truly a fugitive slave and the person claiming that fugitive slave is legally the owner of the slave. The purpose of this is to prevent kidnapping, because what we know is there's a significant amount of kidnapping by Southern slave catchers who go to cities close to the South, Philadelphia, for example. It's important to remember that both Delaware and Maryland are slave states. Philadelphia is very close to Maryland and Delaware. They go to Philadelphia, they go to New York, not because it's close to the South, but it's easy to hop on a ship, and the next day you're on the ocean, and a few days later you are somewhere in the South with the person that you have kidnapped. So the personal liberty laws are designed to prevent kidnapping, to prevent mistaken identity, because after all, how do you prove that a particular African American is your slave? You don't have photographs, you don't have fingerprints, you don't have any of these things. And so the personal liberty laws are designed to protect the free black population in the North. By the 1820s, every northern state has either abolished slavery outright or is in the process of seeing slavery die off through what are called gradual abolition acts, where the children of slaves are all born free, and so literally slavery will die out. New York, for example, passes such a law in 1899. I'm sorry, in 1799 passes such a law. Then in 1817 passes another law saying in 10 years, all slaves are free, even if they were born before 1799. So by 1827, July 4th, 1827, every black person in New York is legally free. But there are a lot of blacks in New York City, there are a lot of blacks in Philadelphia, and kidnapping is a problem. So these are ways in which the Constitution is pro-slavery. It's pro-slavery because of the Fugitive Clause, the Electoral College, the slave trade provision, the Fugitive Slave Clause, and a number of other clauses which protect slavery in a variety of ways. After the Constitutional Convention, one of the leading delegates from South Carolina, General Charles Goldsworth Pinckney, brags about what they've accomplished. He says, we have got a great Constitution. And he says the national government can never end slavery because it doesn't have the power to do so. And this, again, is perhaps the most pro-slavery position in the Constitution, because it prevents the federal government from ever interfering with slavery where it exists. It doesn't have the power to do so. And it will only have the power to do so when the southern states secede. You may remember that when Lincoln becomes president, he says, I have no power to touch slavery where it exists. That's correct in 1861. Once the Civil War begins, everything changes. And as we know, by the summer of 1861, the U.S. Army is freeing runaway slaves. So one piece of the Underground Railroad, of course, is the U.S. Army takes the Underground Railroad into the South during the Civil War. Slaves flee to the U.S. Army, and the U.S. Army ultimately becomes an army of liberation, emancipating people as it moves further and further into the South. So these are ways in which the Constitution is pro-slavery. Now, how do African Americans respond to the Fugitive Slave Law and to the problem of a pro-slavery Constitution? In 1787, there isn't a national anti-slavery law. There are small anti-slavery societies in every state in the North, and there's also a small anti-slavery society in Maryland and Virginia as well, even though they're slave states. These societies are focused on ending slavery in their own states. So the New York Manumission Society lobbies the state of New York to pass this 1799 law, which says there will be gradual abolition, and continues to lobby New York so that in 1817, as I said earlier, New York passes another law saying in 1827, all the slaves in New York will become free. So That's an example of these early anti-slavery societies. Curiously, by the way, the person who signs the 1799 law in New York is Governor John Jay, who had been Secretary of State, who had been Chief Justice of the United States, who was the co-author of the Federalist Papers, who had owned slaves most of his life because, as most wealthy people in the North and the South, you bought slaves. Even if you didn't have a farm, you bought them as household servants. But he signs the law into effect because he's also, by this time, the former president of the New York Society for the Abolition of Slavery. So he is a very early abolitionist. Both his son and his grandson and his daughter and his granddaughter will be active in helping slaves, helping runaways, working on the Underground Railroad, helping create freedom in that part of the country. So how else do people respond? Well, African American slaves respond as they always have. They run away when they can. Running away is not easy. And people often ask, why didn't more slaves run away? And the answer is, how are you going to do it? It's not like you can go to the airport and hop on a plane. You can't get in your car and drive north. And so most fugitive slaves, most runaways, most freedom seekers, and it's useful, by the way, to think for a second about how we use these words, because Southerners call them fugitive slaves. The federal government calls them fugitive slaves. They called themselves freedom seekers, but under the law, under the Constitution, and that's what we're talking about today, they're fugitive slaves because the law says they can't run away. The Constitution says if they run away, the federal government or the state governments can go grab them and bring them back. So fugitive is not a pejorative term when talking about a freedom seeker. A fugitive slave is defining the legal obstacles that they face. And I think it's important for us to understand that because it's always important to understand, and this loops back to how do people respond to these laws, that helping a slave run away is illegal. Under the 1793 Fugitive Slave Law, you could be fined $500 plus have to pay for the value of the slave if the slave was not recovered. But even if the slave is recovered, you could be fined $500. $500, by the way, is an enormous amount of money. It's more than an average worker earned in a year. It's a huge amount of money in 1793. This is one of the highest fines in the federal legal system in the 1790s. And then in 1850, a new law is passed. The new law raises the fine to $1,000 and furthermore says that if a fugitive slave is not recovered, the owner can also get $1,000. So it costs you $2,000 if you get convicted of helping a fugitive slave escape and the slave successfully escapes. In addition to that, you could be sentenced to jail for 6 months. So the penalties for helping fugitive slaves are very high. The risks vary from place to place. In some places, the risks are quite high. There is a man in southern Ohio named John Van Zandt who picks up a whole wagon load of freedom seekers in Cincinnati and is stopped by Kentucky slave catchers as he's traveling north in Ohio. He is successfully sued. He's prosecuted for the $500 penalty under the 1793 law for each one of the slaves he has. And while he dies, while his case is on appeal, his estate is bankrupt. His family loses everything because of his humanitarian act in moving these slaves from Cincinnati into northern Ohio. One of the ones he picks up actually escapes. On the other hand, in other parts of the North, you are less likely to be caught because public opinion is so strongly opposed to enforcement of the Fugitive Slave Law. I'll give you a couple of examples of that. In 1851, on September 11th, a slave owner from Maryland tries to capture a slave in Christiana, Pennsylvania. His fugitive is living in a house in Christiana with other African Americans. They have a big bell on their front porch, which they ring in case there are slave catchers. They ring the bell very loud, notice is given, and literally 30 or 40 people show up to try and protect these African Americans from being brought back to Maryland. There is a shootout. The slave owner is killed. The person who he was trying to capture probably killed him. He then, after the shootout, takes the pistol that had been owned by the dead slave owner, puts it in his belt, gets on a train, and travels all the way to Rochester, New York, where he meets the very famous fugitive, Frederick Douglass, spends a night in Frederick Douglass's house, gives Douglass the pistol as a souvenir, and then gets put on a boat in Rochester and goes to Canada. Douglass is probably not going to be arrested in Rochester because, as Douglass writes in his own autobiography, after 1851, the Fugitive Slave Law was pretty much a dead letter in upstate New York because public sentiment was so much against it. In Christiana, 36 African Americans and 5 whites are arrested. They are charged with treason. This, by the way, gets me to Millard Fillmore, who I'm writing about. Millard Fillmore is who I've written a biography about. Millard Fillmore is president. He's a lawyer. He decides that the Fugitive Slave Law is so important that he wants these people tried for treason. Now, treason is a very specific crime. The Constitution defines treason as making war against the United States. And so 41 people are put on trial in Christiana, Pennsylvania. And in the very first case, the jury reaches the conclusion that whatever these defendants did, it was not treason. They can't be tried for treason. They're not making war on the United States. It's not treason to fight against the Fugitive Slave Law. But there's great expense involved in defending yourself against a federal treason trial. Fortunately for these brave people who helped protect William Parker and his friends, William Parker's the man who ended up in Canada, there were volunteer lawyers who came in and argued the case. One of the lawyers was Thaddeus Stevens, who, as we know, will later be a central figure in the passage of the 13th Amendment ending slavery. So these are ways in which the response to the Fugitive Slave Laws works. In other places in the country, it's far less dramatic. There is a African-American living in Muscatine, Iowa. I don't know if there's anybody on the program today from Iowa. Muscatine is along the Mississippi River, and in that town is a man named Alexander Clark, who was born free, but in Cincinnati, eventually moves out to Iowa. Alexander Clark hides fugitive slaves in his house in Muscatine, helps them get further into Iowa where they're not likely to be captured. Nobody goes after Alexander Clark because in Iowa, the sentiment is so strong against the Fugitive Slave Laws that it's going to be very hard to actually successfully remove a fugitive slave. So these are the kinds of issues that we face. The Underground Railroad, of course, is called the Underground Railroad because it's illegal to be involved in the Underground Railroad. It's illegal to help fugitive slaves escape. So naturally, if you are naturally, if you're doing this, you don't do it in public. The Underground Railroad is not an elevated trade. There's a good reason for that, because you face penalties. You can go to jail. There are abolitionists, black and white, who are sentenced to jail and serve time in jail because they helped fugitive slaves escape in the North. There are, of course, other abolitionists who are caught in the South and spend much more time in jail. And there are a small number of Southern whites who helped slaves escape. The most famous example involves a man named Henry Box Brown. Henry Brown lives in Richmond. He is an urban slave. He is married to another slave in Richmond, but of course, slave marriages are never legal because slaves aren't allowed to be legally married. And when the owner of Henry Brown's wife decides to sell her, Henry goes to his owner and says, please buy her. Please buy my wife. I don't want my children and my wife going south. The owner says, too bad, I'm not interested. That's your problem. And so the last time he sees his wife and children is when they're being marched out of Richmond. He then decides to run away. He'd been willing to live in slavery, even though he didn't like it, because he had a wife and family. He then runs away. He devises a genius plan to run away. He has a white friend who's a carpenter, build a gigantic box. He is put in this box. His white friend takes it to the train station. The box is put on the train and shipped to the anti-slavery office in Philadelphia. The box, of course, has writings on it saying this side up, arrows like this. But the people who are running the railroad don't care, and they turn the box upside down. So Henry Brown travels from Richmond to Philadelphia upside down in a box. It almost kills him, but he does survive. And he then goes to Boston and he writes a book. He becomes known as Henry Box Brown. But once he writes about his escape, he has to go to Virginia. He has to leave the United States because of the Fugitive Slave Laws. Again, the Fugitive Slave Laws force slaves who are well known to go outside the United States. So Henry Box Brown goes to England. He has a very long career as a singer and an entertainer and a showman in England. And then very late in life, well after the Civil War, he returns to the United States. Another famous example of runaways and how the laws affect them are William and Ellen Craft. Ellen Craft is a very light-skinned African-American woman. She's also, fortunately for her, a very slim woman. Her husband, William Craft, is a very dark-skinned African-American. They are both slaves. They devise a brilliant plan for escape. William Craft is a skilled worker. He's able to earn money outside of being a slave. He's able to pocket a little money on the side. He saves up enough money to buy a very nice, fancy suit of men's clothing to fit his wife. His wife, Ellen, then cuts her hair, learns how to act like a man, learns sort of the right gestures for being a man. And she puts a scarf over her face because she has allegedly a very bad tooth which has to be dealt with. And she puts her right hand in a sling. That way she can't ever be asked to write something. And she passes herself off as a young man, with William Craft being her servant. And William and Ellen Craft travel sometimes in first class on trains all the way to Boston, where they live. She passing herself off as a man, he passing himself off as her servant. They live in Boston for 2 years until the passage of the 1850 Fugitive Slave Law. And by then, they decide it's time to get out of the United States. Because what does the Fugitive Slave Law of 1850 do? Let me talk about that. This law creates a massive system of law enforcement. It is the first federal law enforcement system in the United States. It provides that a federal commissioner will be appointed in every county of the United States. So no longer do slave catchers have to worry about what a state judge might say. They can go to a federal commissioner. This is a time when most states have only one federal judge. A few states have 2 federal judges. The federal commissioner will hear fugitive slave cases. It further provides that the federal commissioner can call out the militia, can call out the Army, can call on the Coast Guard, can call on the Navy, can call on whatever it takes to enforce the fugitive slave laws. The fugitive slave laws of 1850 is outrageous in many ways. For example, it prohibits an alleged fugitive slave from testifying at a hearing to determine whether the person is in fact a fugitive. So a fugitive slave can be seized, but can't get up in court and say, hey, you've got the wrong person. I am not this person's slave. It's a mistaken identity. They're not allowed to have a jury trial. They're not allowed to have access to the writ of habeas corpus, even though the Constitution says that the writ of habeas corpus can only be suspended during an invasion or a rebellion. Lincoln could suspend habeas corpus during the Civil War because it was a rebellion. But Congress says we're going to suspend writ of habeas corpus for all people accused of being a fugitive slave. They're not allowed a trial. They're not allowed a jury, even though the Constitution says if you are brought into a federal court, you are allowed to have a jury trial. So the Fugitive Slave Law of 1850 probably is unconstitutional. It never goes to the Supreme Court. And had it gone to the Supreme Court, of course, the court would have found it constitutional because Chief Justice Taney and the majority of the court are pro-slavery. And in fact, there are a couple of cases under the 1850 law in which the court says, obviously, this law is constitutional. So this is the way in which the Constitution is disregarded when it comes to fugitive slaves. I want to just have a little tiny footnote on everything that I'm talking about today, because somebody sent me an email saying that in 1850, on this day, September 18th, in 1851, I'm sorry, on September 18th, the New York Times published its first issue. So today is the anniversary of the first day that the New York Times published. And in that newspaper, it had a story about the Christiana slave rebellion, as it's known. This is the case where the slave shot the man who was trying to return him to slavery. So this is kind of an interesting day to be talking about this because it's an anniversary of when the United States was discovering what had actually happened in Christianity. The 1850 law is designed to recover the thousands of fugitives living in the North. Southerners claim in the 1850 census that they're asked the question, how many slaves have run away from you? Totally, the 1850 census says that there are about 1,000 slaves who've run away from the South just in the year 1849 to 1850. So if we extrapolate that, if it's 1,000 slaves a year, by 1860, there must have been at least 10 to 15,000 people living in the North who had escaped from slavery. The Fugitive Slave Law of 1850, designed to recover all these runaways, in this sense is a monumental failure because the best study of the Fugitive Slave Law of 1850 says that there were only 366 people returned under the law. There are probably more than that. There are probably a few that the scholar missed. But maybe there are 400 that are returned out of the 10 to 15,000 who are living in the North. Nevertheless, these returns lead to enormous political controversy all over the North. They lead to riots in some places. They lead to public demonstrations. They lead to politicians losing their offices, politicians not being able to hold an office because of the anger that Northerners have to fugitive slaves. Give you one more example of this. In 1851, there was both an anti-slavery fair and the New York State Fair being held in Syracuse, New York. An anti-slavery convention in the New York State Fair being held in Syracuse, New York on October 1st, 1851. That's the day the federal marshal decides to arrest a fugitive living in Syracuse named Jerry McHenry. He is quietly grabbed and brought into court, but people notice this, and pretty soon the courtroom is filled with people from the anti-slavery convention and then from the state fair. There's an attempt to spring him from the courtroom. He runs down the street only to be grabbed by police and dragged back, put on the back of a wagon with a policeman sitting on him. And he's yelling while he's on the wagon, "Will somebody give me a knife so I can kill myself? I don't want to go back to slavery." Fortunately, Jerry doesn't have to kill himself, because the next day, a mob of 3,000 people, led by the mayor, led by the leading minister, and led by a man who will later be elected to Congress from the area, surround the jail. Young children are challenged to see if they can throw rocks through streetlights. Kids are always being told not to do that. Now they're being told, see if you can hit a streetlight. Eventually, all the streetlights are taken out by kids throwing rocks, and then the mob goes into the jail, rescues Jerry. He is hidden in the city for about 8 days. And federal officials are looking for him, can't find him. And then the federal marshal notices that a wagon with 4 horses is driving through the town pretty quickly. And the marshal happens to know that these are well-known fast horses and they're not owned by the same person. The marshal figures out Jerry must be on this wagon. Marshal gets a posse, he chases the wagon. The wagon has a good head start. There are toll roads in those days. In those days, the toll road meant that you had literally a wooden barrier that came down. You paid the toll, the wooden barrier went up, and then you got on your way. The toll booths are all open for the rescuers of Jerry. They're closed when the posse gets there, slows them down. And the posse arrives in Oswego, New York, just in time to see Jerry's boat leave the dock for Canada. And he then is able to go to Canada and be free. Canada. Canada, of course, and Mexico in the Southwest are the only places where fugitive slaves can be truly free. Because anywhere in the United States, they are subject to being returned to slavery. Frederick Douglass, of course, is the most famous person to escape slavery, perhaps along with Harriet Tubman. But Douglass at the time is the most famous because in 1845, he writes his autobiography, a narrative of the life of an American slave. And Douglass does something that no other fugitive slave up to this time had done. He outs himself. He says in his book who he is. He says, I ran away from this family in Maryland. This is who I am. I'm now living in Massachusetts. And having done this, it becomes very clear to Douglass that he can't stay in the United States any longer because he's a marked man. He ends up going to England for more than a year and a half. And he returns from England a free man because white abolitionist friends in England raise money to buy his freedom. They hire a lawyer. The lawyer goes to the Marylanders who claim Douglas, and they work out a deal. And Douglas is then allowed to return home. Oddly, there are some extreme abolitionists who condemn Douglas for this. They say that he shouldn't have accepted freedom this way because nobody should be compensated for freeing their slave. Douglas is infuriated by these arguments. Douglas says it's an attack on his manhood. It's an attack on his right to be a free person. And what he says is that we are not acknowledging the legitimacy of slavery by allowing somebody to purchase my freedom. We are simply ransoming me as somebody might be ransomed from a pirate. Douglas says, if somebody robs me and I give him my pocketbook, my money, I'm not acknowledging the legitimacy of giving him my pocketbook. I'm simply acknowledging that he has the force to take it from me. And so this is how he sees slavery. And then, of course, Douglas becomes the most effective African-American advocate of liberty in the country before the Civil War, and remains so really until his death in 1895. We're getting close to the time when we're going to take questions, and I know that some of you have probably already raised questions, and Day's going to come back on in a couple of minutes and ask me some of these questions. And I really want to get to your questions because I want to know what you're asking. But I want to end by saying something about what does all this mean for us today? I once gave a talk as a keynote at an Underground Railroad conference in Iowa, and I began the talk by saying, it's nice to see so many people here in Iowa who favor violating the law and who are praising lawbreakers. And everybody looked around like, what is he talking about? And then, of course, it sunk in. Yeah, we're in favor of violating the law. So when do you violate the law? When is it legitimate? When is it morally legitimate? And in some ways, this loops back to what we teach at Gratz College, because as I said, we have a Holocaust and genocide program. And some of the people that we read about are people who harbored Jews who were being hunted by Nazis, who helped people escape the Holocaust. And we also honor people who have hidden victims or potential victims of genocide in Rwanda, in Bosnia, in Cambodia, in Armenia, wherever genocide takes place. And of course, that's what people on the Underground Railroad did. They were protecting people's lives from unjust laws. The Fugitive Slave Laws were unjust. They were unfair. They were dangerous to those who sought freedom, and they were dangerous to those who helped them seek freedom. But people made the decision that you can't turn a fugitive slave away. Perhaps the most effective anti-slavery piece of work in the period before the Civil War is the great novel Uncle Tom's Cabin. There are lots of problems with Uncle Tom's Cabin, and I think Uncle Tom is unfairly considered to be, quote, an Uncle Tom when he wasn't. He was, in fact, somebody who gave his life refusing to reveal the whereabouts of two women who were hiding from the vicious master, Simon Legree. But there's one scene in Uncle Tom's Cabin which is really important for understanding how people reacted. There is a member of the Ohio legislature who lives in Uncle Tom's Cabin, and he has just voted to support a law to help capture runaway slaves. And his wife in this chapter is berating him. How could you do that? How can you, support capturing these people who are fleeing for their liberty? And he gives this long talk about the Constitution and about the nation and about placating the South and how we have to do this. He goes on and on and on. And then she says to him, by the way, there is this African-American woman and her son who are sleeping in the next room. They were found having crossed the river today, and I've put them up. And after his big speech about how important it is to help runaway slaves, to stop runaway slaves, and to enforce the Fugitive Slave Laws, he turns around and takes Eliza and her child further north to freedom. Because when confronted with the reality of human liberty, people who were not necessarily political, people who didn't think much about this, often took great risks. Not all of them. There's a very famous fugitive slave case in Overland, Ohio. It leads to what's called the Overland Wellington fugitive slave case. The Overland rescue starts in 1858. And it starts because a slave catcher is poking around Overland, which of course has one of the few colleges that is racially integrated, has a very large Black community, slave fugitives and free Blacks from the North living there. And this slave catcher hires a young white man to hire a Black to help him harvest his potato crop. But in fact, what he's doing is hiring this Black man so he can be kidnapped, and he is kidnapped. He's brought to Wellington, Ohio, about 10 miles away. But a mob from Overland, led by Overland College faculty and students, and the African American community, some of whom are, of course, also students at Overland. They go to Wellington. He is rescued. He ends up going to Canada. And about 30 people are arrested and jailed and tried for helping fugitive slaves escape. 2 of them are convicted, and then the trials fall apart because the federal government realizes that they can't find enough jurors to try all these people, because while a fugitive slave wasn't entitled to a jury trial, if you were prosecuted under the law, you were. So these are examples of how the law worked. Day, at this point, I think the audience out there, all of you have been very patient, and do you have some questions for me?
Yes. Well, thank you, Dr. Finkelman. We'll now open it up to questions and answers. So if you haven't already done so, please enter in your questions in the Q&A. I just would like to follow up on something before I put out the audience questions about the last event that you referenced, the Overland Wellington rescue. And in that case, Justice their lawyer, Rufus Spalding, argued against the constitutionality of the Fugitive Slave Law. Can you talk a little bit about if these arguments in legal cases, fugitive slave cases, worked, and to what degree were they effective?
Okay, so they didn't work at the level of getting any judge in the federal system to declare the Fugitive Slave Law unconstitutional. They did, by the way, work in Wisconsin. In Wisconsin, the Wisconsin Supreme Court said the Fugitive Slave Law was unconstitutional. And in a case called Overland versus Booth in 1859, the Supreme Court said, no, it wasn't, that it is constitutional. And Chief Justice Taney said he has never heard of states' rights before. I mean, it's an absurd opinion, because Wisconsin is saying the states' rights of Wisconsin are being trampled by this law. Supreme Court says no. By the way, a tiny irony here. The case in Abelman versus Booth is pretty much a one-off. It's decided 1859, people forget about it. And the next time it's used is in 1958 in the Little Rock cases, when the governor of Arkansas says that the federal courts can't tell Arkansas to integrate its schools. The Supreme Court digs out this pro-slavery opinion and says, sorry, under Abelman versus Booth, we decided a century ago that in fact the states can't interfere with the workings of the federal government. So there's a kind of a sweet little irony that this case is eventually used by the court to unanimously uphold integration. But the state courts, except for Wisconsin's, don't declare the Fugitive Slave Laws unconstitutional. In Ohio, the defenders of the Overland rescuers go to the Ohio Supreme Court and they ask the Ohio Supreme Court to issue a writ of habeas corpus, saying that the federal marshal has no jurisdiction over these Ohio citizens. In a very close vote, I think it's a 5-4 decision, but I don't have it in front of me. The Ohio Supreme Court refuses to issue the writ of habeas corpus, saying, no, we can't interfere. We can't overrule the federal government in this case. The governor of Ohio at this time is a man named Salmon Chase, who will later be Secretary of the Treasury under Lincoln and later Chief Justice. Chase was known as the Attorney General for fugitive slaves. He argued so many cases that he was like the national expert on the Fugitive Slave Laws. He is ready to call out the Ohio militia if the state Supreme Court issues the writ of habeas corpus. He said he'll send the Ohio militia to take these people out of custody, but it doesn't happen. And Spalding makes the arguments, but the arguments don't get anywhere because the federal judge is not about to declare this law unconstitutional, even though if you analyze the law from the structure of the Constitution, that is, that it's in this section of the Constitution where Congress presumably has no power, or if you analyze the law from the number of other rights that it tramples on, like the right to habeas corpus, like the right to a jury, like the right to testify, you could make the argument that it is indeed unconstitutional. That's the Overland story. 2 men are convicted, 1 white, 1 black. The African-American convicted is Charles Langston, who is a school teacher and gives a fabulous speech to the judge before he's sentenced and just levels the judge on any kind of moral grounds. The judge gives him a very light sentence. And Charles Langston, of course, is the brother of the more famous John Mercer Langston, who later becomes the dean of Howard Law School and is for one term a congressman from Virginia after the Civil War. And by the way, their descendant is the great poet Langston Hughes. So it's a very, very important family.
Yeah, thank you. That brings us to our next question, since you mentioned Tawny, from Randy Rosenberg, who asked, in light of the constitutional wording, what was the necessity of the Dred Scott decision?
Well, the Dred Scott decision is not about fugitive slaves. People often think it is. Dred Scott is a slave who was taken to the free territory, which was known as the Wisconsin Territory, later becomes the Minnesota Territory, later becomes the state of Minnesota. He's taken to Fort Snelling, which is in St. Paul. And that area is free under the Missouri Compromise, which was passed in 1820, which said all the territories north of the state of Missouri would be free. Slavery would not be legal north of the northern boundary of Missouri, or west of the state of Missouri in Kansas and Nebraska. So Scott's taken to the federal territory and he later sues for freedom, and the decision should have been, yeah, you're free because your master stupidly took you to a place where slavery doesn't exist. He had also spent 2 years in Illinois where slavery was illegal. But and up until Dred Scott's case, the Missouri Supreme Court had often freed people who had lived in these places. There are about a dozen Missouri Supreme Court cases in which the court says, you took your slave to Illinois, your slave became free, we recognize that change in status. But when the case reaches the Missouri Supreme Court, it's a completely different outcome. The Missouri Supreme Court essentially says, we're no longer going to follow the old precedents because of abolitionism. It then gets appealed to the US Supreme Court. And Tawney could easily have said, we're simply going to follow the Missouri court because it's a Missouri case. Dred Scott remains a slave, and none of us would know about the case today. It would be a footnote. And in fact, that's initially what the court was going to do. But the Southern majority on the court, there are 5 Southerners led by Tawney, can't leave that alone. They can't stop it. And so Tawney writes an opinion in which he says 2 dramatically shocking things. First, he says that Dred Scott can't, oh, by the way, I need to teach you a tiny little bit about real law here. In order for Dred Scott to sue in federal court, he asserts that he's a free citizen in Missouri, and he's suing his owner, who happens at the time to live in New York, but owns Dred Scott in Missouri. And under federal law, a citizen of one state can sue a citizen of another state in federal court. And Scott says, I'm free, and if I'm free, I must be a citizen of Missouri, therefore I can sue Sanford. Tawney says, even if you're free, even if you were a citizen of Missouri, you can't sue because blacks can't be citizens of the United States. This is the first time a court's ever said this. Blacks have been voting in a number of states. Blacks have held public office in some states. The year after this case, John Mercer Langston will be elected the county attorney in Lorain County in Ohio. So under Tawney's theory, you have a guy who's not a citizen of the United States who's the county attorney. You have non-citizens voting for members of Congress, voting in presidential elections under Tawney's theory. He says blacks can never be citizens. There was no reason for him to do this except he really wanted to, because he hated the idea of free blacks. And here's what's interesting. And by the way, if anybody want to read about this shameless promotion, I published a book in 2018 called Supreme Injustice, Slavery in the Nation's Highest Court. I go into extensive discussion of this case there. But when Tawney was Attorney General under Andrew Jackson, 25 years before Dred Scott, he had issued an opinion to Andrew Jackson saying, we can't give passports to blacks because blacks can never be citizens. So in Dred Scott, he simply now has a chance to make this constitutional law. The other thing he says, which is even more shocking, is that Congress can't regulate slavery in the territories because slavery is a special form of property that has special constitutional protection. So in one sense, this question leads me back to the beginning. Does the Constitution protect slavery? Tawney says yes in Dred Scott.
Thank you. Our next question is from Milt Diggins. He asks, Thomas McCreary, a Maryland slave catcher / kidnapper, captured 2 young free black sisters named the Parker sisters in Pennsylvania around the time of the Christiana trial. He takes them into Maryland with taking them before a federal judge with taking them before a federal judge or commissioner. The sisters are rescued, and the Pennsylvania governor points out McCreary violated the Fugitive Slave Law of 1850 by not going before a judge or commissioner before taking them to Maryland. The federal government did not charge McCreary for the violation. Are you aware of any other incidents where the federal government refused to enforce the law when a slave owner or his agent violated the act?
I don't mean to, it's a great question. And the reason I'm kind of chuckling is because I don't know of any cases at all where the federal government ever did anything to harm somebody who was a slave catcher. That is, the federal government never charged any slave catcher with violating any law. So the answer would be no. There's the U.S. government in 1850, 1851, all the way until the election of Lincoln, is a pro-slavery government. Just a quick thought. From the election of George Washington until the election of Abraham Lincoln, though 15 presidents hold office. Of those 15 presidents, John Adams, John Quincy Adams, Millard Fillmore, and Franklin Pierce are the only ones who never owned a slave. All of the Southern presidents owned slaves, but James Buchanan owned a slave in Pennsylvania, and Martin Van Buren owned a slave in New York. Slavery is in charge. With the exception of a 5-year period, a majority of the members of the Supreme Court are slave owners. By the way, many people think Tawney didn't own slaves. He did own slaves. He freed many of them, but he owned a few until his death. The Supreme Court's a slave majority. Most of the speakers of the House, most of the leaders of the Senate are slave owners. It is a slaveholders' republic. And so, no, the federal government isn't prosecuting people for violating the Fugitive Slave Law. By the way, the Supreme Court would probably have said that a master has a personal right to capture a fugitive slave without going to a federal judge. The court had held that in a case called Prigg versus Pennsylvania in 1842. It said that you have a personal right to capture your slave and you don't need to go to any judge to do it. So in that sense, the court would have said, there's no trial here, there's no crime.
We'll have one more question before we close up. We've talked a lot about the US Constitution and slavery, but this question is, what did the Confederate Constitution say about slavery?
Well, the Confederate Constitution is interesting. It reaffirms the ban on the African slave trade. Remember, the US Constitution, because of demands from the Deep South, had protected the slave trade until at least 1808. Slave trade is, by this time, dead, although there are plenty of people who illegally try to bring in African slaves. And so the Confederate Constitution prohibits the African slave trade. And I sometimes run into sort of neo-Confederates who say, you know, the Confederacy was more anti-slavery than the United States because it banned the African slave trade. But the rest of the Confederate Constitution has a number of provisions which explicitly protect slavery in a variety of ways. One of the things the Confederate Constitution says is that you can travel to any Confederate state with your slave. In other words, the Dred Scott issue is never going to come up because there aren't going to be free states or free territories. Even if a Confederate state ends slavery, it still has to recognize slavery within the Confederate state. The Confederate Constitution guarantees in writing that the Confederacy can never end slavery, and does a few other things. I unfortunately don't have the document in front of me to point them all out, but I believe you gave everybody my email on a slide. Is that right?
We'll be giving it in just a second.
Okay. If you want to send me the email, I'll be happy to answer the question in greater detail. My email, by the way, is easy. It's president@gratz, Gratz.edu, president@gratz.edu. I'm happy to answer questions. This is a very important subject.
Thank you, Doc. Thank you, Dr. Finkelman. So that concludes our question and answer period. I apologize for any of you that didn't get your questions answered, but if we have the next slide, it has Dr. Finkelman's email, where you can email him, or if you have any questions or concerns about the event today, it also has my email. Is that up there yet? There it goes. I also encourage you to visit the Network to Freedom website to find more about International Underground Railroad Month. For you constitutional buffs out there, you can check out Dr. Finkelman's article that appears there, and that link was included in your registration confirmation email. There are also some articles on the 15th and 19th Amendments and their roots in the struggle against slavery, so I encourage you to check all those out. And also, we are now on social media, so be sure to follow us. Now I would just like to conclude by thanking a few people. First of all, thank you, audience, for bearing with us in your participation in today's event. Thank you again, Dr. Finkelman. I would also like to thank the Network to Freedom staff for their support of this event, Diane Miller, the National Program Manager, Sherry Jackson, and for all of you with the National Park Service, I'm sorry, I'm going to use our former regional names because there's a lot of non-Park Service people that might not understand the region numbers. So Sherry Jackson with the Southeast region. And our new team members, Kamal McLaren, who is now the Northeast National Capital, or DOI Region 1 Regional Manager, and Amanda Pollock, our new Visual Information Specialist. Last but not least, I would like to thank the staff of Gratz College for handling all the technology for this event, and a special thanks goes out to Dottie Klimoff for making this event a success. As I said, for those of you who would like to watch this webinar later, you will be receiving information when it is available. Again, thank you much for joining us, and have a great weekend. Goodbye.
Thank you all. Goodbye. Have a wonderful weekend. Stay safe.